G'day everyone, and welcome to week 6 of our course on legal ethics and trust accounting. Last week we began our examination of the duties that a solicitor has to their client by looking at the duty to provide timely and competent advice and the duty to act within your client's instructions. This week we're going to look at the cornerstone of the relationship between solicitor and client, that is, client confidentiality, which is also sometimes described as legal professional privilege or client professional privilege. Australian Solicitors Conduct Rule 9.1 says a solicitor must not disclose any information which is confidential to a client and acquired by the solicitor during the client's engagement to any person who is not either another solicitor in the same firm or a barrister engaged on behalf of the client. In general terms, what this means is that once you learn something from a client, then unless you have instructions to pass that information to someone else, the information is confidential and you must keep it secret. Even people who know very little about the law know that anything they say to their lawyer will be kept in confidence. The privilege is so strong that you as a lawyer cannot even be forced to disclose in court anything that you've been told in confidence by a client. This was confirmed by the High Court in a case called SO Australia and the Commissioner of Taxation, and it's also been written into sections 118 and 119 of the Uniform Evidence Act 1995, which applies to Commonwealth cases. The reason for this confidentiality is that our justice system, which is an adversarial justice system, works best when both sides are able to bring their best case before the judge. That can only happen if each party is able to be completely full and frank with their legal practitioner. Clients need to know that whatever they tell you, you're going to keep it in confidence. There are a few elements to the privilege. First and foremost, the person has to be a client. So if some random person at a family barbecue knows that you're a lawyer and starts doing a classic drunken overshare telling you all sorts of personal stuff, that doesn't raise the privilege. You only owe the duty of confidentiality to a client. Having said that, for this purpose, a person becomes a client before there is a retainer. So if you're speaking with someone who is a prospective client, while you try to work out whether you can help them, or while you're trying to work out what sort of cost estimate to give them, you're already in a situation where you owe them a duty of confidentiality if the other elements are met. In a century-old case called Minter and Priest, Minter was trying to sell property to a buyer named Taylor. Taylor went to Priest, a solicitor, to see if he could borrow money from the firm to purchase the house. Back in those days, it was very common for law firms to provide mortgages. Priest, the solicitor, said slanderous things about Minter, the seller, but he also refused to provide the loan, so Taylor never became a client. Minter tried to sue for slander, but Priest successfully saw off the claim on the basis that the statements were made in privileged circumstances, even though there was never actually a retainer. So as soon as somebody comes to see you as a lawyer, not just say as a footy teammate who happens to practice law, as soon as they come to see you as a lawyer, the communication is privileged. The second element is that the communication must be for the dominant purpose of the client obtaining legal advice or contemplating or conducting litigation. Once upon a time, the test was whether the sole purpose of the communication related to legal advice or litigation, but that was quite restricting because any sort of advice is potentially likely to have some sort of ancillary usefulness. Now, as long as the communication is between solicitor and client, and as long as the communication is for the dominant purpose of obtaining legal advice, then the privilege will be attracted. The authority there again is SO Petroleum and the Commissioner for Taxation. Finally, the privilege attaches to confidential communication. Let's start with communication. Communication is given a fairly broad reading. It includes, for instance, obviously oral communication, but it also includes emails, text messages. It can include statements made through an agent or a litigation guardian. The actual mode of communication is really quite irrelevant. Communication is not just limited to finished products either. It includes drafts, scribbled notes made while talking to the client, scribbled notes made by the client, and so on. However, the communication has to be confidential. Not everything that a client communicates to you is intended to be confidential. For instance, quite obviously, if a client instructs you to make a settlement offer to the other side, then clearly that can't be a confidential communication. If it was, well, then you couldn't make that settlement offer to the other side. In civil matters, there's a whole process called discovery or disclosure that's about providing information to the other side. So how do you tell the difference? The first thing to do is go back to our material from last week. You should constantly be thinking about what your instructions are. If you have instructions to disclose materials, then clearly the materials are not confidential. If you don't have instructions to disclose, then obviously, if you disclose those materials, you're not only risking a breach of client confidentiality, but you're also risking the possibility of acting outside your instructions. You see, the key here is that the client owns the privilege. The client decides whether you can release material or not. If in doubt, seek instructions. But even more importantly, if in doubt, assume everything on the file is confidential, then clarify. It's too late once you've breached confidentiality. It's also very clear that the client can abrogate or breach the confidentiality. You see, for the communication to be confidential, it needs to be kept within that solicitor-client relationship. If the client discloses the communication, for instance, if they take your legal advice and stick it on the GoFundMe page that they've set up to cover their legal costs, well, then it's no longer privileged. It doesn't have to be public like that either. If your client reveals privileged information to any third party, the privilege is lost. This is an old rule, but made clear by the High Court relatively recently in a case called Mann and Carnell. When a client does waive privilege in relation to a document, they waive privilege in relation to the whole document. You can't waive privilege in relation to part of a document. Finally, it's crucial to understand that the duty of confidentiality continues permanently. It does not end with the conclusion of the retainer or the conclusion of the matter. Anything that you learn in the course of providing advice is permanently privileged. This will become super important next week when we begin talking about conflicts of interest. So that's a basic outline of the concept of client confidentiality. In the second video this week, we're going to look at this duty in action. In a day-to-day sense, how do firms ensure that they are complying with the duty of confidentiality? And then in the third video this week, we're going to look at some exceptions to the rules, circumstances in which you are no longer bound to keep client information confidential. On to video 2.